also our sponsor and guests. Thank you. Welcome you. On behalf of the firm, I also welcome you. Let us directly go to the issues which we think are very much relevant and also important for the economic development of the country. The keynote presentation relates to legal issues involving trade. There are fair trade has many issues which directly indirectly relate to trade, but we are, as a law firm, we are focusing on legal issues. Let us briefly, we have participant and panelists who will discuss on the fair trade object, but just to introduce what is fair trade, I just will take 1 or 2 minutes to describe fair trade in a nutshell. If you can kindly go through the slides. Fair trade is an organized social movement that seeks to promote fairness and justice in local international trade through dialogue and transparency. Its stated goal is to help marginalized producers in developing countries. Movement is recognized by UN and EU by bringing changes in regulations. Briefly, it's all about ensuring fairness and justice in trade. There are sellers, there are buyers, there are agreements, there are international laws. The idea is to promote marginalized buyers and sellers who are basically located in the developed countries, so that they can operate business at a profitable manner. Buyers who purchases goods from outside, from developed countries, so that they also take care of the sellers as well as care about the price and try to be a bit more responsible for the entire industry. Let us quickly cover the areas. I'm not going to focus on all the areas, but in a nutshell, I'm just going to cover which will in turn come in discussion by respectable special guests and also panelists. First of all, law, which are related to trade and also fair trade. World Trade Organization's rules, they frame rules. They also involve in signing various agreements. Secondly, United Nations Convention, they draft different kind of trade convention. For example, ancestral arbitration model law is there. There are other conventions which are directly related to trade. Thirdly, there are best practice and terms. For example, UCP Incoterms, these are not binding, but if parties agree to incorporate, in that case, these are binding. These are suggested best practice regarding LC, suggested best practice regarding shipping, transportation term, and these are issued by ICC. Thirdly, rules, regulations of other member organizations. For example, IMF, World Customs Organizations, on labor issues, on customs related laws and issues. Finally, national laws, regulation and dispute resolution system. National law regulations which has a duty to go in line with international conventions, and also the way dispute is resolved has directly impact on fair trade, because the longer the disputes are, the parties are actually more or less depending on how quickly disputes are resolved. Then comes practice. Practice is between buyer and seller. How responsible business they do between buyers and sellers. How as a businessman they have some responsibility to make the business profitable for all. Secondly, other related industry, not only buyer and seller, banks and carriers and freight forwarders, they are directly indirectly related to trade. Accordingly, they are also how careful they are about how responsible they are with regard to business. This is also related. And last issue which we think is directly related to fair trade is awareness and motivations. And this seminar is definitely one of our objects to raise awareness as well. Because even if there are laws, but our sellers, buyers, banks, carriers, freight forwarders, and also regulators, they also need to aware of the rights and liabilities under existing laws, whether there are any changes required, whether any modification is required, or to know the best practice, all these things. This is also related, not only knowledge on law, but also on dispute resolution mechanism, because there are different ways of resolution of dispute. And normally, this is we have found from our experience that buyers and sellers do not incorporate arbitration mediation clauses normally in the international sales contract. It's normally a one-page contract. So this is, we believe, due to lack of awareness. Now we are going to come to the legal issues which we are here to, I'm here to talk on. First of all, present status of Bangladesh in compliance with international convention. Bangladesh has definitely ratified the model law, ancestral model law on arbitration, which is ratified by Arbitration Act 2001. Secondly, Bangladesh has ratified all Hague conventions, but except there are 2 new Hague conventions, but these are also disputed. Not all the countries have ratified, but Bangladesh have ratified first and second version of the convention. Thirdly, issues which I've already pointed out, that there are confusions among buyers and sellers regarding trade terms, and also confusion on trade disputes and also trade practices. Various types of practices are prevailing, which actually creating more confusion. Lack of knowledge and awareness of international law. Finally, this is one of the issues we are going to highlight, the slow dispute resolution mechanism. So we will be addressing it in the next slides. Our 2 objectives, 2 recommendations we would like to make. Number 1, there is a need for ratification of CISG, which is an international convention, UN Convention on Contract for International Sales of Goods, which is actually passed in 1980s, briefly known as CISG. Presently, 83 countries has ratified. If you kindly go by year, we have also mentioned the year in which country has ratified it. So initially, there was not many countries ratified, but it's going on and on and on. Because you see, kindly see the Congo just ratified 2015, Madagascar ratified 2015, and Bahrain 2014, Brazil 2014, Singapore, Japan, all the European Union countries, all United States, Australia, China, Canada, almost most of the important countries who directly impact our trade actually ratified the convention. The benefit of this convention is that it is all on about terms and conditions between the between buyer and seller, and it is a standard law. There are laws. If you sign a contract between in one country, if you're sitting in one country and signing a contract of a seller or buyer in another country, then there will be issues of confusion. Which law will be applicable? So these conventions try to actually harmonize the law. They have collected all the best materials from different countries and passed the convention. Once a country ratifies this convention, then that country, buyer and seller and even regulator, then banks and other related industry who are more or less dependent on trade, they don't need to bother about sales. What will be the terms and condition between buyer and seller, because it will automatically operated by this convention. Unfortunately, UK has not ratified, because when this convention was passed, they had a different idea, and following that convention, neither India nor Pakistan nor Bangladesh has ratified it, probably due to Commonwealth background. But probably it is now a good time, because if you can see, even in 2015, new countries are going on ratifying them. Let us briefly discuss on the differences between CISG and Sales of Goods Act 1930, which is presently in operation in Bangladesh. CISG is a known and familiar international law, whereas Sales of Goods Act is a local Bangladeshi law. If we ratify CISG, our law will be international. Secondly, few terms our buyer and seller regularly use, but they do not know their impact and why they are using, and from where the source are coming, they really do not know. For example, mostly the discounting, if you kindly see in the banks and among all the businessmen, those few of them are also here, discounting is a very popular term. Sometimes Bangladesh is now an globally integrated country. They are selling more and more garments, leather and other products. When they are selling, if there is any discrepancy in the quality of goods, they see that they ask for discount. But actually they do not say that they are applying CISG. But they are actually applying CISG because their country has ratified it. They know that they have that right and they will apply. But our buyer and seller get confused that why they are asking discount and on what basis. This is a very serious issue, and this creating confusion among buyers and sellers. Not only that, there are other issues of repairing. If your goods are faulty, can you ask for a repair? And if you can ask for it, under which law? Our law do not support. Our sales of goods, there is absolutely no terms here which talks about repair, who talks about discounting, which talks about extension of time, what it will be the consequence of delay in case of delay in delivery. So this is need to be, there is definitely a need to address this issue. CISG has other benefit because it is a collective law. It is harmonized all the standard practice of the world, and it is really a fair, just and balanced law. Finally, when there is a disputes of issues is disputed, that which honorable court will decide. If Bangladeshi seller is exporting a goods and that goods is rejected, then for example, the seller is exporting the goods to Germany, and if the goods is rejected, then in which court he is going to file a suit for asking for compensation. If the CISG incorporated, then honorable courts will clearly know which law to apply. There is a conflict of law, but conflict of law principles are not yet settled. Our second recommendation would be to need for a separate commercial code. There are in UK, there is a separate commercial code, but Bangladesh do have Admiralty Code, and our chief guest, and not only chief guest, but honorable judges are here. They have presided over the Admiralty bench of High Court Division. But the problem of Admiralty Code is that it does not resolve the dispute between buyer and seller. It only relates to claim which has some link with ship, vessel. But that Admiralty Court is a specialized court. It is under the jurisdiction of High Court. But if any seller, he has delivered goods but has not received any payment, normally under the present law, the seller is need to file a case in the Joint District Judges Court or court below if the money amount is less than that. But Honorable Joint District Judge has so many issues to deal with. For example, the same court is also a specialized tribunal for authority matter. The same court also deals with land-related matters. Same court also deal with other normal contractual disputes which are not related to sales of goods. Then it really becomes difficult. And as well as this is a specialized area of law, it really needs expertise. Normally, it's a time estimate we have given. We do have few clients for whom we have asked for money, so filed money suit, which is still pending. But it may take up to 6 years to get a first-hand judgment without taking into account the appeal and further appeal to the appellate division. It can take up to 2 to 6 years to get a first-hand judgment. So this is definitely a serious issue. This itself is bringing unfairness, because ultimately the money claim will, the claimant is actually becoming disappointed and they are even planning to withdraw the suits. I've given a comparison. Probably my time is running and quickly just going through the slides. Commercial claims, what are the advantage and disadvantage for having a separate commercial court? It can be, our honorable judges can say very well that whether opinion on that. But in UK, as there are claims who are actually taking advantage of it. We have seen it from our practice. They know that if they do not pay immediately, if bank reject a LC claim, that will not pay because you haven't give this much document, you please give us this document. Bank reject to pay. But then the bank also knows and the buyer also knows that he is not really required to pay even within 6 to 7 years. Even more than that. This itself is creating a serious unfairness affecting our international business, because all the local LC is actually back to back, somehow relates to master LC. So this is my presentations, and our recommendations is, again, we really believe that there is a really need for a ratification of CISG, and there is a need for establishing a separate special commercial court. Thank you.